Wrongful dismissal. It's a term you hear often, but it doesn't mean what you probably think it means, and that could cost you. And more importantly, we'll reveal the true definition and how employers can avoid wrongful dismissal claims on this week's episode of the Employment Law Minute. Welcome to the Employment Law Minute, where we talk about common workplace issues and explore practical solutions for both employers and employees. I'm your host, John Scholes, and I'm joined by Ottawa employment lawyer Alex Lucifero, partner at Samfiru Tumarkin LLP. Right to it, pal. Wrongful dismissal. It's a term often misunderstood. What does it actually mean?
Well, this is probably one of the biggest misconceptions in employment law, John. It's a question that we field day in and day out. Ultimately, at the end of the day, what a wrongful dismissal actually means, it's simply that the employee has been paid the wrong amount of severance. So it's an issue of severance. It doesn't necessarily have to do with why the employee is being terminated or the reason behind the employee being terminated. Ultimately, that's oftentimes, almost always, a matter of very little significance. The wrongful dismissal occurs when the employee is paid the wrong amount of severance when they're let go. That's what's problematic. So in that respect, wrongful dismissals aren't very rare. They're actually very, very common. Right. Employees get mispaid, or they get paid much, much less than what they're actually owed more often than not. It's often the case, when we see severance packages, that those severance packages are simply, cents on the dollar of what they're actually owed. So that's what's wrongful about a dismissal. It's an extremely common occurrence that employees are paid the wrong amount of severance, inappropriate amounts of severance. And typically those kinds of matters, when we're talking about these kinds of wrongful dismissals, in which really the only issue is severance pay and what the appropriate severance period is for an employee, oftentimes those situations are very, very easily resolved by way of some negotiations.
It's all about the money when it comes down to it. So an employee that has been wrongfully dismissed, how is severance calculated?
In most cases, John, severance is going to be calculated on the basis of your age, your position, and your years of service. So the longer you've been with the same company, the older you are, the more senior your position within that company, the more severance you're going to get. It can range for a employee in their 20s who's been with a company for under a year, let's say, maybe in a laborer or a clerical position. It could range from a couple of weeks to as much as 2 years of severance. That's generally the maximum when it comes to severance, or the cap that they put on severance, 24 months on 2 years. For most employees, severance is going to be in the several months of pay, sometimes significantly more than that if you're a longer-term employee. And again, we're looking at considerable amounts of money here. If you take what the average annual salary is for an employee, several months of pay is going to be a lot of money. It's going to be much more than whatever minimums the Employment Standards Act provides for. And oftentimes what people get wrong about terminations is the reason why they were let go rather than the amount that they've been offered.
If I'm an employer watching this right now, I'm thinking, how do I avoid a wrongful dismissal?
Well, there's actually two relatively straightforward ways to avoid a claim for wrongful dismissal or a claim for inappropriate severance. Number one, either provide the right amount of notice or the right amount of pay to employees based on their age, position, and years of service, and offer them up that amount so that there is no dispute about what they're actually owed. You're offering it to them right then and there. If instead, as an employer, you want to limit the amount of severance that you're paying, you want to restrict that as much as possible in order to keep your costs down, you want to insert into your employment contracts or into your offer letters language that limits an employee's termination entitlements. It's perfectly legal to do as long as you're in line with what the Ministry of Labor and the Employment Standards Act provides as an employer. And when it comes to termination and severance pay, you can limit an employee's severance in a contract of employment. You've got to make sure that language is very carefully drafted, and you have to make sure that that contract is enforceable. But that's certainly the best way to limit a potential case for a wrongful dismissal. In either case, John, whether you're an employee thinking that you've been wrongfully dismissed, or you're an employer considering letting an employee go, you want to contact us and get advice on the situation. As an employee, you can be leaving tens and tens of thousands of dollars on the table, accepting a severance package that's less than what it should be. And as an employer, it could cost you tens of thousands of dollars if you offer an employee less severance than what they're actually owed.
Good stuff there, my friend. We're going to leave it there for now. Are you experiencing an issue in the workplace? Contact us now. help@employmentlawminute.ca to reach out. 1-855-821-5900. Go to employmentlawminute.ca. You'll find past episodes of of the show, resources for employers and employees, as well as contact information to help you find practical solutions to workplace problems. EmploymentLawMinute.ca. Thanks for watching. We'll catch you next time.